first type of trust I want to talk about is the revocable living trust estate plan. This applies to anyone that might die, which is 100%. So the typical client could use this type of trust to avoid probate, protect certain kinds of assets from creditors, divorces, and lawsuits if used properly, and transfer assets to their loved ones in a way that is much faster than what it would cost and the delay and time that would be involved in going through probate court. Now, if you've ever been through it, you understand already that probate is expensive. It takes time. It costs delays. It can go a year or two in order to transfer asset ownership from the decedent over to the people that they want to receive it. A lot of people think, well, I'll do a will. That'll avoid it. No, a will simply is a memo to the probate court to tell the court who gets the assets after claims of creditors and bills being paid and so forth. With a living trust estate plan, you avoid all that. Within a couple of weeks, everything can be privately protected and transferred to the people you want to get it. Isn't that better? Doesn't that make more sense? Of course it does. One of the advantages with the living trust is they don't get all caught up in probate. They don't go through the hassles and the delays that are normally associated with it because, frankly, they don't want to deal with lawyers and courts and delays and possibility of having their estate frozen while some creditor claim gets dealt with. With the living trust, it quietly and privately gets distributed in a timely fashion in a way that's in accordance with their wishes. Moreover, they can build incentives in the trust that benefits their heirs. So let's say that I have passed away, my spouse has passed away, and now my children are the beneficiaries of my living trust. I'd like to have incentives in there, and we can do that. We can build them right into the trust. For example, I'd like my kids to be entrepreneurs. I'd like them to be real estate investors. I'd like them to give jobs to other people by employing them. And I'd like them to be patriots who support their country, who are good citizens, participate in the community, and make the world a better place. Guess what? We can build incentives for inheritance right into the trust. In addition, we also want to protect those kids if they go through a divorce or a lawsuit. If you have kids, as a parent, probably the last thing you'd want is for the inheritance that you leave to your children to be broken up and divided in a divorce proceeding. After all, maybe your kids who are little right now, maybe they haven't yet met their future ex-spouse. And if that's the case, you want to protect them so that when they do inherit, they inherit in a way that keeps that inheritance as their sole and separate property, and it doesn't go away because they get divorced or because they go through a lawsuit. We can protect them with the proper type of planning built right into the trust. Next, who should be the trustee of your living trust? Well, the good thing about it is you can be your own trustee. If you're single or if you're married, either way, you can be your own trustee as long as you're alive and medically competent. If you go into a coma or you have a stroke or you pass away, someone called the successor trustee can now step into your shoes and handle things in accordance with your instructions. So, for example, you might name your best friend as a successor trustee if both you and your spouse have passed away. If not your best friend, then maybe your favorite brother or sister or cousin. It might be somebody from your church. It might be a coworker, someone that you feel has got the responsibility and the personal integrity to follow the instructions that you leave them. That's who you'd pick as your first choice. And then you'd want someone else to step in as a successor trustee if something happens to that person. So I usually suggest that clients have a first choice, a second choice, and a third choice just in case something happens to the first two. But in either case, you want someone who has personal integrity to serve as your successor trustee, because their job is to step into your shoes and make distributions just like you want. Of course, the next question is, what can be owned by the living trust? Well, it can own just about anything, but normally people have it own their personal accounts. I don't mean your business accounts that are in your corporation or LLC, but your personal accounts, the ones that you pay college tuition with for your kids, or the one that you pay your cable bill or utilities with. You also want your personal property, your collectibles, your electronics, your DVDs, your TV, your car, all those kinds of things owned inside your living trust, your boats and recreational things, and of course, your personal real estate, your personal residence. Your investment properties need to be held separately inside of your LLCs or corporations, depending on how you set that up, and later we'll address how best to own those. But the things that are in your living trust, they escape probate. They don't go through the creditor claims. They don't go through divorces that your kids have. It can go directly to your heirs, completely avoid probate, and with good planning, they can get to your kids and to your heirs in a timely and private fashion. Now you can see in this graphic how assets would be transferred for a single person who's not married. By using the living trust and having those assets held inside of the living trust, at death there's no need for a probate. Certainly we've avoided conservatorship, and we have the assets transferred over to the people you want to benefit with a minimum of delay and without the involvement of outsiders. And now, of course, in this graphic, we've seen how it works for a married couple. They're able to transfer assets into the living trust. It benefits both of them while they're alive. When one of them passes away, you've got the A trust and the B trust, which fold into the overall living trust. And then those get distributed down to the heirs at the death of the second spouse, without probate, without involvement by outsiders, and with a minimum of disruption, right to the people that you want it to go to. Well, as usual, I've given you a lot to think about, and I'm sure you may have some questions. If you do, I'd be glad to help you in any way I can. This is Attorney Michael Potter, and I look forward to seeing you next time.